Hey guys, welcome back to the channel. Today we're diving into a major follow-up on a case I thought was wrapped up the first time I covered it. What started as a simple one-and-done hearing turned into something much bigger and a lot darker. The original video was titled, "When Playing the Victim Backfires," but trust me, that was only the beginning. In this update, we're breaking down several hearings that happened both before and after that video went live, including some deeply troubling footage tied to his alleged crimes. This one is going to be a full detailed breakdown, so buckle up. There's a lot to uncover. Let's get into this video and see exactly what went down.
All right, this is 241136, the state of Michigan versus Christopher Moore.
Good morning, Your Honor. Jessica David for the people, P86743.
Well, Your Honor, Jeffrey Fianto on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore and, for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number, and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for a hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case, behaves poorly in a courtroom, that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate under the judicial canons for me to do so.
Unfortunately, I don't have that landlord-tenant footage, but after watching everything I'm about to show you today, I can only imagine the absolute dumpster fire of chaos that went down on Zoom that day. Honestly, if being a jerk in a previous hearing was enough to get recused, this guy would have walked free without a single prosecution.
Judge, if I would request the matter be set for tomorrow morning. I'm going to be here. Mr. Moore will be here.
Okay. It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
I have landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Miss Maudlin, maybe we'll just do it around 11:30.
I think there was another case.
All right, let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Miss Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. Circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Miss Davidova, you're free to appear via Zoom. Miss Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Sorry, go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Miss Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I had asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you in person at the 23rd District Court. Your attorney is requested that you get here a half hour before that hearing at 11 a.m. All right, I'll see everyone tomorrow at 11 a.m. or 11:30.
Spoiler alert, he didn't show up. And I'm willing to bet the reason is simple. Deep down, in the empty corners of his mind where any normal person's brain would kick in, he knew that if he walked into that hearing, he was heading straight to jail. 40.
Mr. Fanto, we've got you in here. This is 241136SM, the People versus Christopher Moore.
Good morning, Your Honor. Jessica Davidoff for the People, P86743.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Moore. Judge, Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building. To their knowledge, I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So he's a flight risk. He certainly, at least appears to be based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And once he is located or picked up or turns himself in, the court will send you notice, okay?
All right, at this point in the timeline, my previously published video comes back into the picture. When I first made that video, I had no idea what I know now, and let me tell you, that makes the next clip we're about to watch even more chilling.
Moynihan, is there anything you have to say as to bond?
Yes, Your Honor. Thank you. Tina Moynihan on behalf of the People, P84692. Judge, we were in court on Monday. I was there as a prosecutor covering the docket for Ms. Sob and Ms. Davidova, and Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment, and then Mr. Moore decided to log off before the case was ever called. My understanding, he then contacted the courthouse and spoke to a clerk downstairs and made threats to the court that if he came up to the courthouse that something was going to happen to people in the courthouse. And then it was also my understanding of speaking with the complainant who appeared by Zoom that there was an incident in the night prior, which would have been Sunday night. In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering the portion of his face. He then enters the complainant's bedroom. He pulls a gun from his pocket and then shows that to the complainant, claiming that her fingerprints were on that gun and putting her in fear of an altercation ensuing. Further from that, he's then seen leaving the location by the complainant and heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence, and I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not returned to that residence, and then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10%, with a GPS tether and house arrest if he were to be released. And I would ask that there be a 2-mile radius from the complainant's residence so that he's not to return to that area.
Honestly, that video was almost funny when you really think about it. He claimed he was set up and even broke down crying in front of Judge Shackelford, all while knowing full well there was clear video surveillance of him committing the crimes. This guy really redefines the word dumbass. He's managed to turn a $500 bond and a simple domestic violence charge into a staggering $250,000 bond plus 7 additional felonies. And now, we move on to today's wildest hearing, where he fires his brand new attorney just hours after the previous one was excused, and a replacement was barely hired.
Mr. Moore would like another attorney. So we probably have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can handle I'll do the arraignment, yes.
All right. I mean, he
Yes.
needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did
Okay.
explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be,
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay. So, Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
okay,
Honor,
well,
we stand here to make the formal reading of the warrant on the charges, Your Honor.
Okay. So, Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I was sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she didn't have the discovery package. This is all falling on the error of not myself.
And just like everything else that's ever gone wrong in his life, it's never his fault. It's always everyone else's. It's his attorney's fault he doesn't have his discovery, even though she was only appointed hours earlier. It's the mother of his child's fault that he assaulted her and ended up with a domestic violence charge. And again, it's her fault when he escalates to a felony home invasion, breaking into her house and threatening her with a gun while she held his child. Finally, of course, it's the camera's fault for actually catching him doing the whole thing.
I'm just sitting here and I was explaining to her.
Okay, well, Mr. Moore, listen, Miss Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to respond.
All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't say anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion? What are you talking about? When did this happen, ma'am, Your Honor?
I'd say you're well past the point of just playing stupid, but then again, I'm not convinced you were even pretending. The offense went down on August 12th at 2 a.m., and don't worry, we'll jog your memory with video evidence in just a minute.
Is there a date?
All right.
Mr. Moore.
Mr. Moore, listen. You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein. And while entering, present in, or exiting the dwelling, Shamani Butcher was lawfully present therein and was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and/or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons felony firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met. contrary to MCL 750224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon Shamani Butcher with a dangerous weapon, to wit a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 8 is weapons felony firearm.
There's any charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right, well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit a handgun, at the time he committed or attempted to commit a felony, to wit assault with a dangerous weapon, contrary to MCL 750.227B. This is a felony punishable by 2 years consecutively, with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence, and the allegation is you did make an assault or an assault and battery upon Shamani Butcher, an individual with whom you have a child in common, contrary to 750.81, parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a 4th offense notice on your information or complaint. This was all on August 12th at what time, ma'am? There's not a time on here. It said it's at August 12th at this location. No, I'm still reading, Mr. Moore.
There's more?
And it gets even worse. As she was reading your charges, you were so busy trying to get your 2 cents in that you completely missed her saying you were being charged as a habitual offender. Let me spell it out. Given the nature of your charges, a conviction could mean a minimum of 20 years behind bars and a maximum of life in prison. So maybe it's time to zip it and actually pay attention while she goes through your prior convictions and explains why you could be looking at life.
Notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about October 19th of 1995, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 in violation of 750.535A in the Detroit Recorder's Court for Wayne County in the state of Michigan. Listen. And on or about 2/16 in 1996, he was convicted of the offense of breaking and entering a vehicle to steal property over $5 in violation of MCL 750.356A-B in Detroit Recorder's Court for Wayne County in the state of Michigan. And on or about December 9th of 1999, he was convicted of the offense of police officer fleeing 3rd degree in violation of MCL 750.479A3 in the 3rd Circuit Court in Wayne County in the state of Michigan. On or about 3/31 of 2000, he was convicted of the offense of assault with intent to do great bodily harm less than murder in violation of 750.84 in the 3rd Circuit Court for Wayne County in the state of Michigan. I'm not done. And on or about 4/26 of 2013, he was convicted of the offense of uttering and publishing in violation of 750.259 in the 44th Circuit Court in Livingston County in the state of Michigan. Therefore, defendant is subject to the penalties provided by 769.12. The penalty is life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. So that is the information alleging all of the charges, or stating all the charges that you have, sir, as well as giving you notice of that 4th offender notice.
Oh, I'm sorry. Are you done? Ma'am? Your Honor.
Sir, I just want to remind you, Mr. Moore, we're not adjudicating this case today. Okay, this is not a trial. This is not a trial.
I didn't
This
understand.
is an arraignment. At an arraignment, you are to see and hear the charges against you, which I've now read into the record. And the other purpose is to set bond and notify you of your next court dates. It's not the date where I look at all the facts and the evidence and make any sort of determinations. Today is specifically
Because these
to
are all
set
alleged.
bond. What's that?
Because these are all alleged allegations, right?
Absolutely.
Okay. That's why I was asking you, because I was gonna say on August 12th, there's no way that possibly happened.
All right, well, don't say any more. See, now you're trying to talk to me about the case.
That's why I asked you. That's why, okay, so don't say nothing now, because it's not the time to say it.
It is not the time, and anything you say can and will be used against you in court of law.
I'm not worried about it. I'm not lying about anything. I got nothing left. So that's why I was just asking what it was. So for the record.
Oh, okay, so all right, so Mr. Moore, we'll get you a new attorney. The 2 misdemeanor cases are just going to follow the felony matters. So the 2 domestic violences will just go in and we'll work on those as your case proceeds through the 23rd District Court. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Sharmani Butcher.
So there's no way of being able to talk to my son in any way, shape, or form either.
Sure, isn't the son at issue an infant?
He's 19 and a half months old.
I'd say this is one of those rare moments when a father really shouldn't be around his child. And don't get your hopes up. If the stars somehow align and you somehow get the minimum sentence, you won't see your son again until he's 21 years old.